This morning, Mr. Femi Falana joins us now. He is a senior advocate of Nigeria and a human rights activist. It is good to see you this morning. Well, we would have wished that you were in our studios, but we don't know. Are you back in Lagos or you're still in Port Harcourt?
Back in Lagos. I'm back in Lagos.
Oh, you're back in Lagos. Okay. Well, you certainly had your day in Port Harcourt, and you had some words, but some of them were not very friendly for the organizing committee in terms of the choice of those who were invited to that particular conference. And you didn't think that former president of Liberia, George Weah, was one of those who should have been speaking, because you said he did not quite, he didn't quite uphold the rule of law when he was in office as president, particularly rulings coming from the ECOWAS court. What has been the response of the Nigerian Bar Association to some of the criticisms that you have leveled against it?
Well, the Nigerian Bar Association cannot challenge me because I handled two of the cases that I cited, because other President George Weah, about 4 judgments of the ECOWAS court were disregarded, but I handled 2 of the cases. And my position, because the truth of his submission is that you may have a civilian president who behaves like a dictator. I mean, if he has no respect for the rule of law, if he harasses the media and the rest of them, you know, so he can't be called a genuine Democrat. And those are the characteristics of President Weah when he was in power. The media, even though his regime decriminalized freedom of expression, but the media, so the radio stations were closed down, the journalists were hounded. In fact, there was a BBC journalist who had to be handed out of the country. So that was the atmosphere that operated in Liberia. And I did say that because citizens lost confidence in the judiciary in that country, they had to rush to the ECOWAS court for legal redress. So nobody has challenged the fact that he complied with court orders. And in particular, the current president, President Buakai, has already set up a committee to implement one of the 2 judgments that I cited. Yep.
All right. Well, that wasn't the only thing that caused a bit of controversy. I do know that lawyers were divided over whether or not social media activist VDM ought to have been invited as well. What did you make of that?
In those days, the NBA brought individuals who had paid their dues, who were coming to engage lawyers intellectually. We wanted to learn from them, and so the NBA was not our conferences were not. None of our conference was a circle show in the past. You know, so if you are bringing in an expert to discuss the security of the country, either from the private or public sector, such an individual must have contributed to the security architecture of the country. But when you bring people who have nothing to do with the security of the country, there are problems. It's like talking about media freedom, press freedom. You are going to bring practitioners in that field, either in the academics or in the newsroom. But to just go and bring somebody from nowhere to come and entertain you, there are problems with that. And I think that was the problems associated with that particular lecturer, individual.
Well, I'm sure that, I do not know whether you've seen the response of some of your colleagues, some of them very senior as well. I'm going to be citing the response of Professor Chidi Odinkalu to that particular one. He says it's customer feedback, that the law and the courts are for everyone, and the lawyers who are like say, advocates in the temple of justice now, I'm trying to look for the particular word that lawyers use, should not shy away from listening to feedback from people who have cause to always, interact with the law. And that's how he sees it. Do you share his perspective?
With profound respect to my very good friend Chidi Odinka, he was talking in a general sense, but we're talking of this particular case. I mean, if we are talking of justice delivery in the country, we now want to hear from members of the public. That will be okay. But if you are talking about the security of the country, it does require that you bring people who are involved in maintaining the security of the country, or who are victims of abduction and the rest of them. So, as lawyers, we must link up with members of the public. We must hear from them, but not in specific areas which require some kind of expertise, so that lawyers can learn and be positioned to take care of their own security, as well as the security of members of their family. For instance, we're talking about state police now, and you would expect anybody who's going to speak in that area to tell us when we had regional police in the country, why did we embark on centralizing the police force? Why are we now going back to what we had in the First Republic? I think this is the kind of problem that was associated with some of the speakers that have been brought to address us. In those days, the submissions of some of our lecturers, like the late Dr. Akeola Aguda, when he addressed us in 1985, or the late Justice Oputa, when he addressed our conference in 1987, for several days and weeks, their submissions became matters of public discourse. Editorial comments were written on them. Lawyers debated them even after the conference, and we learned from them. And I think lawyers are saying we should go back to that era. I mean, take my own case, for instance. There are African leaders who believe in the rule of law, who promote the rule of law in their country, who obey court orders. Who obey court orders in their country. So if you are going to have a former head of state to address lawyers to talk about democracy or rule of law, then you must bring some who can say, when I was in power, there was not a single court order that I disobeyed. I didn't lock up people illegally. I didn't harass the media, and so on and so forth. And there are a couple of them in the continent, if you want to be educated. Thank you.
All right, Mr. Falana, let me bring you back, to the courts now, especially as we prepare for the 2027 elections. In what state would you say our judiciary is as we go into the polls? Would you say that it has been able to discharge itself creditably well in some of the cases that have come before it as we prepare for the 2027 elections?
No, there is no indication yet that the Nigerian judiciary is positioned to address the challenges that may emanate having regard to some conflicting decisions with respect to the elections that are likely to take place in January and February next year. But for me, I think the first matter to address is the role of the judiciary in the electoral process in Nigeria. We must stop the practice whereby the courts determine the winners of election in Nigeria. You just had an election in Osun State. Forget all the shortcomings. At the end of the day, the beauty of it will be that the governorship election will not go to court. Because the people have decided, they've elected their leader. So no court should be allowed to hide under technicalities, to torpedo, as it were, or to make a mockery of the popular choice of the people. So for me, the role of the judiciary will have to be extremely limited in the democratic process in our country. And again, a lot depends on the media, the INEC, and all concerned Nigerians to ensure that elections are properly conducted, to ensure that no fake results are announced, so that you limit the area that people may want to go to election petition tribunal for, or the regular courts or the appellate courts. So we must start with the conduct of good elections, so that, as it is in most African countries, our courts will have limited role in the democratic process. Secondly, and that was what I was expecting lawyers to do in Port Harcourt, elections are coming. And this suggests the Bar Association must quickly convene a meeting attended by election experts among us, lawyers, so that the bar can let them know the feeling of members of the public with respect to the role of lawyers and judges in the democratic process in our country. The media, too, must also ensure that elections are properly monitored and well reported, as we had in the case of Osun State. Once we can put the machinery of having credible elections in place, of course, for me, the role of the judiciary will be limited. And when tribunals are called upon to intervene in the democratic process, everything must be done. No court should resort to technicalities or crass legalism to deny the people the right to choose their leaders. That's my position, you know.
All right, let me quickly take this to Ayo, because I know he also has further questions for you. Ayo.
Thank you very much, Marpe. Mr. Falana, that position raises a bit of a question, because as we have also heard from legal practitioners such as yourself, the judiciary is not Santa Claus. They don't just dish out anything. The judiciary is not the one that goes to anyone. The judiciary is a place where lawyers come to. Can we excuse lawyers from whatever decision a court in Nigeria takes? Because it is the lawyers that are going to make the case. It's the lawyers that are going to argue for or against the case. And so when the decision is going to be taken, the judiciary or the courts are just going to hold whatever position they see based on whatever evidences are laid before them. Why should those cases in the first place, Mr. Falana, go to the courts if the legal practitioners or the legal industry, so to speak, agree that some things ought not to go to court?
Please, can you come again? I didn't quite.
Okay. I'm saying that the courts is not Santa Claus. They don't just dish out gifts to anyone. Someone goes to court and then the other person comes to defend. In this case, usually legal practitioners, and which is why you also said that lawyers should have a round table to discuss these things. Some cases ought not to go to court, but then it would seem like every case goes to court. And so can we really blame the courts for whatever decision is held when it is the legal practitioners, the lawyers, that take those cases to court in the first place?
Lawyers. And in this case, most petitions are handled by very lawyers. In our legal side, concerns are being expressed, and we're to call ourselves to order. And that was why I demanded from the NBA, I demanded that the NBA should call an urgent conference of lawyers, particularly those who have the election petitions, so that We can advise us, we can get us. And no cases that should go to court. And when these cases go to court, and judges must ensure and they do in some other jurisdictions very bad cases to court. Lawyers are, and that was what happened when President Trump and his support filed about 62 petitions. Many of them, because judges have read them, withdrawn because the judges threatened to sign or refer such lawyers to the disciplinary committee. Here, we allow every action filed in court. And when to election petition, our judges must move speedily to strike out frivolous petitions. The part of Synod or the part of the Nigerian Bar Association, because most of these cases are reported, we must also be able to call ourselves to order. But when judges have to decide cases, they must not determine them on the basis of technicality. You can't say, whereas INEC officials should have used a red pen, they use a blue one, therefore we are nullifying result. Oh, INEC should have stamped the back of a ballot paper because it was not done. We are going to cancel 165,000 votes. No, that should no longer be permitted in our country.
Well, Mr. Falana, in your response to the first question Mark asked about the readiness of the judiciary or legal practitioners for the 2027 elections, your response is that it doesn't seem like we are ready. So the question then will be, what are the gaps we need to fill for us to be ready? Because it is known by us all, even in the build-up to the Osun State governorship elections, it was just about 24 hours or thereabout that a particular case was resolved and INEC had to do the needful. The kind of pressure that INEC must have been put under when materials ought to have been distributed at that time, I think one can only imagine. So what are the things that we need to do ahead? What are the gaps we must fill? What warning should go to legal practitioners and even the judiciary about these elections so that it's far less contentious than the ones we've ever had?
For instance, it is totally unacceptable to deliver rulings or judgments in respect of elections that are 24 hours away or 36 hours away. Just like the case of Osun, I didn't know the miracle. What INEC did was simply miraculous by including the name of a party that was not on the ballot, barely 24 hours after a court gave a decision. That decision was enough to postpone the election, and INEC would have the rights, and the public would then have decided on the judiciary that maybe it was planned. And so for judges, these cases ought to be decided within 1 week. In a pre-election matter, you want to find out whether somebody has a school certificate, whether he went to school or not. Why should that take weeks or months to decide? When in fact, why sitting on that table? The judge can do the needful. I once gave evidence in a case in the United States of America. My flight was delayed. And the lawyer representing me in that case, incidentally in Nigeria, Honorable Kayode Oladele, informed the judge that I was airborne. And the judge asked, can we have the details of the flight? He supplied it, and the judge found out, case adjourned to tomorrow. And the court found out that indeed I was airborne. If the contrary had been the case, that would have been enough reason to get that lawyer dispatched in the United States of America. So we must get to that level here where our judges, particularly in pre-election matters, in election matters, because they are time-bound, judges must not allow lawyers to browbeat them or blackmail them into adjourning cases when they are not necessary.
Well, Mr. Falana, recently you also said that Nigeria does not have what you call electoral integrity. Now, is that as a result of our laws, a result of the political class, the democracy we practice, how we practice it, or what exactly drew you to that conclusion?
It's impunity of the ruling class. Again, you go back to Osun. From reports in the media, about 30 people have been killed. Nobody is being prosecuted. Somebody threatened a senator, threatened or rather incited people to attack members of another political party. Even though, based on public pressure, the senator was arrested. Why has he not had his day in court? I also have a case where a man who never contested the election in the NURTW is sitting in the secretariat, national secretariat of that body in Abuja. I'm talking of Mr. Oluomo. Baruwa was the one elected, pronounced elected by the National Industry. A stranger is in the office of the headquarters of Abuja. Mr. Baruwa went to his office, with the government. He was arrested by the police and charged before the court. We cannot operate that way. We cannot operate that way. We have a country where judgments are obeyed. If you have a regime that does not obey judgments of court, including the decisions of the Supreme Court, then you can't talk of democracy.
Well, if we are saying, Mr. Falana, that there is, if we are saying that there is widespread impunity, particularly concerning elections, and we want electoral integrity, then which agency of government or who should be holding anyone to account? We know that INEC has to collaborate with security agencies and the rest of them. And we have been complaining about these things for the longest time throughout this republic. So who should be bearing the brunt? Who should we hold responsible? Who should Nigerians be holding responsible for this lack of electoral integrity? Or are we just going to resent to complaining all the time?
No, parts of the ruling class are not prepared to get elections in Nigeria. Again, we have to go back. When we had the problem in 2007, the president of the country, the late General said, the election that brought me to power is at the floor. I want to stop the manipulation of elections in Nigeria. A panel was set up, headed by the late Chief Justice of Nigeria, Muhammad Uwais. That one of his recommendations is that we should have an electoral offences commission. Every regime since then, every regime has.
Okay. Well, we have to thank you very much. For some reason, we couldn't quite hear you at the end. But we thank you very much for your time this morning. We know that it's an ongoing conversation because, hey, January is just a few months away and we know issues are still going to arise. Mr. Femi Falana is a senior advocate of Nigeria and a human rights lawyer. Thank you again for your time today.